Hi everyone, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're talking about New York's dram shop law. Now, what is a dram shop law? It basically means that people who get injured due to, let's say, a drunk driver, for example, could sue not only the drunk driver who hit them and his, as the operator of the vehicle and the owner of the vehicle and the insurance for the vehicle, but they also may be able to sue the restaurant or the bar that served this person, either if the person was already visibly intoxicated and they continue to serve him or her, or the other way is if they're serving someone who's underage, like not 21, like 18, 17, that's illegal. So there's two different statutes. So we could talk about it. I actually did a CLE about this. There was a CLE that, as part of a group that I'm in, the New York State Trial Lawyers Academy, and I thought it was a really good CLE. So I have some of the slides from the CLE, and I thought that I would share it with my viewers just to give more education and give more explanation, because maybe people don't know that this even exists, right? Or that you have these rights. So we could talk about the statutes, the actual laws, how do you prove a case, the main defenses, and we could also talk about the interplay with no-fault law and possible future legislation that's out there. So what is the law? So the original dram shop law in New York is under General Obligations Law 11-101. And what it does is it creates liability for a seller of alcohol when an intoxicated person to whom the seller made an illegal sale causes injury. So basically, it's for example, if the seller of alcohol sells alcohol like beer, wine, hard liquor to somebody who's already intoxicated, and then that intoxicated person goes out and causes injury to a third person, the third person is the one who has the claim against the establishment, like the bar or the club. So there's also Alcohol and Beverage Control Law 65, which defines an illegal sale for the purposes of dram shop. And there's General Obligations Law 11-100, which gives liability for anyone that provides or assists in providing alcohol to a minor that then causes injury due to intoxication. So under the common law, liability exists for a property owner when they are aware of an intoxicated person on their property. They are aware that the intoxicated person needs to be controlled, and they have the ability to control the intoxicated person, and thus someone is injured on their property due to the intoxicated person. Now, turning to General Obligations Law 11-101, that's the original dram shop law in New York State, and it was enacted in 1921 to discourage activities of bootleggers during Prohibition, when alcohol was illegal. But however, similar laws existed for decades before, like in the United Kingdom and other countries. And the statute was challenged as a nullity after the end of Prohibition, but these challenges were unsuccessful. And so only another act of the legislature can remove the statute. So we still have the statute on the books. And because the statute creates liability that did not exist at common law, it must be strictly or narrowly construed. And this is a common theme throughout the case law. Any ambiguity in a legal interpretation must be resolved in the favor of a defendant. So it has as a strict construction statute. 11-101, it creates strict liability for sellers or purveyors of alcoholic beverages when they commit an illegal sale of alcohol. And it basically says, quote, any person who shall be injured in person, property, means of support, or otherwise by an intoxicated person, or by reason of the intoxication of any person, whether resulting in his death or not, shall have a right of action against any person who shall by unlawful selling to or unlawfully assisting in procuring liquor for such intoxicated person have caused or contributed to such intoxication, and in any such action such person shall have a right to recover actual and exemplary damages. So, the way they write these statutes, it's a little bit complicated. I don't know why they write them so who they're writing them for. But, basically you could break it down. To break it down, you have to say, what types of cases does this law, 11-101, apply to? So the types of cases in which they call it the Dram shop law, the Dram shop law applies, are pretty broad. So it's usually used in motor vehicle collisions, but it's also regularly used in intentional assault cases, like whether simple or sexual assault, and one of the few ways that insurance coverage can apply for an intentional assault. And it also applies to property damage cases, which include vandalism. And then you could also say, what is strict liability? Strict liability in this law means that a defendant is liable simply because of the violation. So if you violate the law, you're liable. And there is no need to prove that the defendant was negligent or intentional in its violation, just that the violation happened. However, this does not mean that the defendant will be liable for the entirety of damages. Comparative fault defense is still available to dram shop defendants. So they could say, hey, we were at fault, but the plaintiff was also at fault, and the comparative fault of all the parties. And the most common comparative fault issues in a dram shop case include a plaintiff getting into a car or continuing to drive with a known intoxicated driver and instigating or antagonizing an intoxicated person that provokes an assault. And then what is an illegal sale or procurement? Now that's the critical thing, right? Because it makes this sale, it says you can't do an illegal sale, right? If you're a seller of alcohol, like a bar, a club, a restaurant, you can't illegally sell alcohol, right? So what's illegal, right? That's the key heart of the whole statute. So the statute creates liability for anyone that unlawfully sells or unlawfully assists in procuring liquor for an intoxicated person. And this is defined by the definition of an illegal sale under Alcohol and Beverage Control Law 65. And it basically says no person shall sell, deliver, or give away or cause to give away any alcoholic beverages to, number one, any person actually or apparently under the age of 21 years. So that's an illegal sale, right? If you give alcohol to anyone under 21. Number two, any visibly intoxicated person. So if somebody's already visibly intoxicated, let's say they're slurring their speech, they look like they've been drinking, they have alcohol in their breath, they don't have balance, right? Any signs, it has to be like, I guess, objective, outwardly signs of visible intoxication, you can't continue to serve them. And then any habitual drunkard known to be such to the person authorized to dispense alcoholic beverages. And that category is more like a relic from 1921. I don't think that's really going to be, unless like, you're a bar owner and hey, Jimmy, he's a habitual drunkard, don't give him alcohol. But that's like, that's kind of a rarity. So really it's those two, under 21 or visibly intoxicated person. What is an illegal sale? So despite these statutes' use of language regarding procuring and giving away alcohol, the Court of Appeals, that's the highest court in New York, has limited liability only to defendants engaged in the commercial sale of alcohol and where there is an actual sale. So you can't be just giving it away. It has to be an actual sale and commercial sale, not like in someone's house, but commercial, like a restaurant, bar, club. However, this does not always require money for alcohol transactions. For example, in the case of Abate versus Black Wolf, they allowed a dram shop claim against a restaurant when the restaurant offered a no-corkage fee party. So the intoxicated person drank wine that he or she brought from home, and the restaurant was deemed to have still committed an illegal sale due to the commercial value of the no-corkage fee, because it has some value. Say, hey, come to my restaurant, no-corkage fee. You can drink wine, you buy some dinner, some entrees, whatever, appetizers. I guess that has some value, they said. And so because of that, if they were still serving the person when they're physically, they're pouring the wine, even though it's their own wine that they brought from home, but they're saying, hey, you're pouring this wine, and they're visibly intoxicated, and they go out and they hurt someone, the restaurant is liable. Now, General Obligations Law 11-101, who is any person? How do you define that, right? So any person generally means what you would expect. However, it does not include the intoxicated person themselves or their estate. Let's say the intoxicated person gets killed. It can't be their estate, right? It can't be them. If they get hurt, there's no lawsuit, right? Because they're choosing to drink. So this means that the person whose intoxication caused the injury cannot recover against the entity that illegally sold them alcohol. Similarly, the next of kin cannot bring a wrongful death claim against that entity. So it's any person that assisted in procuring the intoxication of the drunk person is also precluded from bringing a claim. So if you're like out with your friends, and let's say one of the friends is the one ordering, getting you shots and giving you the shots, even though the bar is giving it to you, if you then are driving and you hit a tree and you hurt your friend, if the friend was helping you get those drinks, the friend can't sue either. So basically anyone that procures alcohol and the drunk is visibly drunk, not anyone that procured a single drink for the intoxicated person. And the standard is identical to that of the defendant. And drinking buddies are not precluded simply because they engaged in drinking with the intoxicated person. So I guess it's not like a drinking buddy wouldn't be, but somebody that procured or obtained the drink for the visibly intoxicated person, they would be. So it turns on the evidence of witnesses. The most common type of illegal sale is to an intoxicated person, and that's the Beverage Control Law 65. And there are many ways that a person can appear intoxicated, and it includes slurred speech, being argumentative or aggressive, a flushed face, sweating, or stumbling or trouble walking, like a balance issue, right? So, however, evidence of a high blood alcohol content or high levels of consumption are not enough to show that a person was visibly intoxicated. The courts recognize that alcohol affects each person differently, and some can drink more than others and not be as intoxicated. So that's interesting because, usually that's evidence, right? Like if you get pulled over while driving, they say, hey, you blew like a .20, you're drunk, but they're saying evidence of high blood alcohol content is not sufficient, probably by itself, because you probably need some of this stuff like slurred speech, argumentative, flushed face, sweating, and if you had the .20 or whatever, .15, that would probably work together. So it's not like you can't just have the blood alcohol content. And how to prove visible intoxication? Well, a seller of alcohol needs to have some knowledge that the person to whom they are selling is visibly intoxicated. And the best evidence is witness testimony, which can be from the person that served the drunk themselves, drinking buddies, other patrons or individuals that observe the drunk, and surveillance footage is also helpful if available. An expert opinion is of limited value because BAC alone is insufficient, but it may be helpful if there is evidence that the drunk was visibly intoxicated at the time of injury and their drinking activity is what led to the injury. And then what types of damages are recoverable? So the law permits recovery of actual damages related to personal injury, property damage, loss of support, or otherwise. Meaning, means of support is an individual damage suffered by any individual, usually a spouse, child, or parent, even if an intoxicated person's estate is precluded from bringing a claim due to their own intoxication, there may still be surviving claims for the family. And then damages include payments made to the family by the injured or deceased person, medical expenses incurred by the family, funeral expenses, and there's no recovery for loss of services, affection, or consortium. But to qualify for a means of support claim, a plaintiff must show that their injured or deceased person had a legal obligation to support the plaintiff or had undertaken an obligation to do so. And recovery for a means of support claim is not reduced by a decedent's share of fault. And the defendant cannot seek contribution from an estate to compensate for a means of support payment. And that's the Bartlett case in the Fourth Department. Other types of damages that are recoverable, there's also this language or otherwise that can allow practitioners to get creative with claims, although damages would have to have some relation to the defined categories. And like there's a case, Winjay, this is actually a very interesting case, also out of the Fourth Department up in Syracuse. What happened was plaintiff was driving her car at 11:30 at night and she saw an object in the road and she tried to swerve to avoid it, but she couldn't, and she hits this what she thinks is an object. So she gets out of her car to check on what she thought maybe is an animal or some kind of object, but then she sees instead it's a body of a man without his head. It's like a decapitated, and she hit this guy and I guess she killed him. But he was intoxicated at the time of death. He had been drinking at a local establishment. So then she, the lady who hits him and kills him, brings a successful lawsuit against the establishment for emotional harm suffered as a result of killing this drunk. Because she's like driving and like this drunk walks in, hits him by accident, tries to swerve. And she's saying, well, I'm emotionally distraught. And it's a valid case. You could do that. But there are limits. And for example, the limit is there's no Grieving Families Act. Like we have a Grieving Families Act, but it hasn't been signed by the governor. So for example, a parent cannot bring a claim for emotional injury of losing their child when the child was killed by a drunk driver. So let's say that same establishment serving this drunk driver gets out, instead of running in the road and getting hit by a car, he's driving a car, he hits like a child who's in a crosswalk, kills the child. There's not really any claim because the child doesn't provide any pecuniary or financial support to the family, right, to the parents. So it kind of like doesn't make sense, right? I did another video about this where I think it's like a crazy law. So like the lady can recover for hitting a drunk for her emotional distress, but yet a parent who loses a child because they served a drunk cannot recover anything. It's almost like doesn't make sense, right? But that's what the law is until they pass the Grieving Families Act and have emotional type injury recovery for wrongful death instead of this pecuniary only, which is like from the 1800s, some kind of antiquated law. And the case on that is Marsico versus Southland. Also, that's from the Second Department, but that's still the law that you can't sue for an emotional injury of losing your child. And exemplary or punitive damages are allowed in dram shop cases, but the standard to prove punitive damages is high. The wrong complained of must be morally culpable or actuated by evil and reprehensible motives. The goal is not only to punish the defendant, but to deter them, as well as others who might otherwise be so prompted from indulging in similar conduct in the future. And exemplary damages are not covered by insurance policies. So if awarded, they would need to be paid by the defendant personally. And then they go to the other law, 100, and say, what is that? Well, that's the one where you can't sell alcohol to anyone under the age of 21. And anyone could be liable under 100. Unlike 101, the section is not limited to entities engaged in the commercial sale of alcohol. So that means a common type of liability would be like house parties or homeowner policies, right? If somebody is serving alcohol to, let's say, a 20-year-old in a house, and then that 20-year-old goes out and, is drunk and kills someone, hurts someone, that person who gets hurt can then sue the homeowner. Under the homeowner's policy, they could sue for a house party, anything like that. But the homeowner must be aware of the underage drinking and authorize or assist in procuring alcohol in some manner. So if a bunch of kids are having the party, right, and the parents are off like away in the Caribbean, well then no, right? Because you have to show that the homeowner knew, either was aware of or authorized or assisted in some way. Yeah. But even other minors can be liable under the statute. And then what does it mean to procure alcohol? It just means using one's own money to purchase alcohol, contributing money to purchase alcohol, giving away alcohol to another after purchasing it with one's own money, or retrieving alcohol at someone's direction for their consumption. So those are all the ways that you define procure. And they say the list is not exhaustive. And although procuring appears in General Obligations Law 101, it is essentially a nullity. So they don't really look at procuring too much. And then he was saying, this is interesting, he was saying, what about underage drinking and fake IDs? Well, the Alcohol and Beverage Control Law 65 states it is illegal to sell to anyone that is actually or apparently under the age of 21. But the General Obligations Law 100 creates liability for anyone that furnishes or helps procure alcohol for someone under 21 when the person does so with knowledge or reasonable cause to believe that such person was under 21. However, this language does not mean that defendants are liable just because the intoxicated person was a minor. Defendants are permitted to argue that the minor presented a fake ID when acquiring alcohol, which would reasonably convince a person that the minor was in fact of age. And the defense is not absolute. The fake ID must be sufficient to fool a reasonable person. And that's the E2 versus Cumberland Farms case in the Third Department. And then they say, what about proxy sales? Businesses have no duty to investigate possible indirect sale of alcohol to underage drinkers. So I guess if you sell it to an adult and then the adult gives it like in the parking lot to a kid, well, the business isn't liable for that. And similarly, purchasing a large quantity of alcohol does not give rise to a suspicion of underage drinking. However, a business can be liable if there is evidence that the seller had a direct reason to know that the sale was a proxy for underage drinking, including when an underage person accompanies the buyer to the register, or when the cashier sees a known underage person in the parking lot who is known to associate with the purchaser. So yeah, unless there's some kind of evidence, right, of that. And then they say, what about company manuals and policies? Many businesses have internal handbooks, manuals, and policies to prevent the sale of alcohol to underage individuals. However, these policies do not create any standard of care that can create liability under the dram shop statutes. And this is based on the general rule that where internal rules require a standard that excess reasonable care, that is, I guess, greater than reasonable care under the law, breach of that rule cannot be considered evidence of negligence. And I guess the reason they have that is because, you know, if you have this standard and you're going to create, like, say, a company policy, hey, in our store or in our bars all across the country, we don't serve, you know, alcohol to minors. And if your standard is higher than just whatever the dram shop is or whatever the law is or the common law, they don't want people to then sue you because you created this standard, right? So nobody would create standards. People would just say, don't make any laws, don't make any rules, right? Because they don't want to be sued. So that's why they have that. There's other things. There's party host liability. There's the no-fault law. So basically with party host liability, there are usually two types of claims that can be brought against the party host or homeowner with regard to drunkenness or intoxication. The party host can be liable for underage drinking under section 100. However, the party host must have knowledge of the underage drinking and authorize or assist in procuring the alcohol for the party. The landowners also have a common law duty to prevent injury from an intoxicated person when the injury occurs on the defendant's property, under the defendant's control, the defendant had an opportunity to control the intoxicated guest, or the defendant was reasonably aware of the need for control. And then the no-fault law, when a claim is brought under the dram shop law arising out of a motor vehicle crash, the plaintiff does not need to prove a serious injury threshold against the dram shop defendants. So that's an important point too, right? Because if you, say, get into a motor vehicle crash and then, you know, you, against the drunk driver, you still have to prove, you know, I think you have to prove serious injury, right? Because that's an auto case against the car, the insurance for the car. But when you sue, let's say, ABC Tavern, who served the driver and he was visibly intoxicated, you don't have to prove serious injury against the establishment, which makes it easier for the plaintiff. And liability against the intoxicated driver will still be dependent on satisfying the serious injury threshold. However, it is possible for a case to be dismissed against a driver for lack of serious injury, but to continue against a dram shop or establishment like the bar, restaurant, or club that serve the alcohol. Yeah, and then they talk about future legislation. They talk about whether there will be, because New York legalized the recreational sale of marijuana in 2021, whether the existing dram shop law will be limited to alcohol, or whether it's going to extend to marijuana. Marijuana intoxication is linked to impaired abilities, particularly driving, just like alcohol. And there's Vehicle and Traffic Law 1192. It's also illegal to sell or provide anyone under the age of 21. And that's Penal Law 222. But should New York consider a dram shop style legislation for cannabis? So that's like a question. Yeah, so that's basically the law on that. So it's interesting. There's a lot of cases, but I thought the craziest thing was that, like, if you hit the guy and you're the one who killed him, but you could sue. But then, like, if your child gets killed, you can't sue because there's no pecuniary loss, no monetary loss. So it really does not recognize human damages, emotional damages. That's why we need the Grieving Families Act. So we need to support that so that gets passed. But like I said, please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. All the best, everyone. Bye-bye.